In this film, we're going to look at how you fill in the financial statement if you have to do it yourself. You have to fill in this form if you are going to court about a financial issue after you've split from your husband, wife or civil partner and live in England and Wales. Solicitors will call it Form E. Until recently, most people could get free help from a solicitor to fill in this form, but now lots of people have to do it themselves. It's a bit of a daunting prospect, so that's why we've made this film to help. I'm not a lawyer, so I find it tricky too, but this is how you do it. You have to start to fill in this form as soon as possible, because it can take ages to find all the information and documents you need, and you need to send it in 35 days before the hearing. I can't imagine you're watching this purely for entertainment, so you might want to go and get your financial statement form now so that you can see what I'm talking about. You might want to pause me several more times as we go along so that you can see what to fill in where when filling in your own form. If you want to skip to a particular question, the numbers will appear along the bottom of the screen. You can find the form on the HMCTS website or just type Form E into a search engine. Click on the file next to Download. You can either print it off and fill it in by hand, as I'm about to do, or you can do it on the computer, whatever's more comfortable for you. Now, if you're doing it on the computer, the important thing is never to press this button. It will delete everything you filled in. And of course, remember to save it regularly. It'll be very frustrating if something goes wrong and you have to do it again. If you are going to print it off, it's best not to print it double-sided. The thing you will probably have noticed straight away, and will probably have made you feel a little bit sick, as it did me, is how long it is. But don't worry, you can do it bit by bit and take your time. If you don't have lots of valuable stuff and you don't have your own business, then there'll be lots of it that you don't need to fill in. So, front page. There is a box in the top right-hand corner that says to be completed by the relevant party. That's me, apparently. The name of the court I can find at the top of the paperwork I've been sent about this. And the case number, again, it's on the paperwork. The applicant is the person who has asked the court for a financial order. Again, that's me. The respondent is my ex. Next, on the left-hand side of the page, there is a box with the word of above it. I put my name in this box as it is my financial statement. I was married, so I tick the spouse box. And for now, I'm going to leave the date blank, as this should be the date you finish the form. Below that, the parties are me and my ex. Next, I tick more boxes. I'm a spouse again, because I was married, and I'm the applicant, and this is a financial relief application. And my ex is the spouse, also the respondent. I ignore the third line of tick boxes and again tick financial relief application. At the bottom of the front page is a box next to the words "This statement is filed by." As you don't have a solicitor, you put your name and address in this box. The next few questions are quite easy. I just have to fill in my details. So I'll jump on to the next slightly tricky one, which is 1.10. This asks about children of the family. This just means any children you and your ex have together, any stepchild, adopted child, and any other child whom you have both treated as a child of your family. A child can be a child of the family, even if they are the child of one or neither of you. If you aren't sure, then just put them down and the court can decide. Question 1.11 asks about your health and the children's. You don't need to put anything here unless one of you has a health issue or disability that affects your income. For example, it means you couldn't work more hours. If you put anything down here, you will need a medical evidence to back it up. If you don't have any issues, just leave it blank. Question 1.12 asks for information about the children's education. So for me, both my girls go to Summerfield Primary School. Next year, our eldest Nicola will move to secondary school, but we don't know yet which one. The next one asks about any arrangements you've made about child maintenance. This might be something you've sorted out between you, done through a child maintenance service or with the help of a mediator. We've not sorted anything out yet, except to agree the kids will live with me for most of the week, so it will be my ex who pays some child maintenance. If you haven't sorted anything out yet, what you can do is go onto the calculator on the Child Maintenance Options website. You put in your details, and at the end it gives you an estimate of how much child maintenance he should pay, and then you write it down. The next section you only need to fill in if you are asking the court to change an existing financial order. If you are, then you need to explain which parts you want to change here. Next, you need to give details about any other court cases between you and your ex, even if they're finished. So I just put in the details of our divorce case. Question 1.16 asks for the address where you are living now, who else lives there, and the basis on which you live there. This might be as a tenant, a lodger, an owner-occupier if you own your own home, or just staying with friends. I'm staying with my mum until I can find somewhere permanent, so I'll put that. Okay, section 2, your financial details. You need to take your time on this section and be completely honest. If you forget to include something, it may look as though you're trying to hide things. If you're not sure whether to include something, put it down and let the judge decide. The other thing to notice is this grey box. The grey boxes tell you what documents you need to include to prove what you say. So, 2.1. You only fill in this section if the last home you shared with your ex was owned by one or both of you and it has not yet been sold. If you've rented it or sold it already, you just move on to the next section. My ex owns the flat and still owns it, so I have to fill in the details. Then it asks for the land registry number. If your home is registered, and most buildings in England and Wales are, it will have a title number identifying it. If you have the land certificate or a copy, you will find the title number there. Alternatively, ring your mortgage company and ask them for it. Or, if like me, you don't have this information and the mortgage isn't in your name, then just write down you don't know. There's lots of questions here about the mortgage. Account numbers, type of mortgage, amount outstanding, if the mortgage company would charge you if you sold now, etc. These details should be on your last mortgage statement, or you can ring up and ask. Or, if like me, you don't have any of these details because it's in your ex's name, you just write, don't know. Details of who owns the property and the extent of your legal and beneficial interest in it. Okay, so if you own your own home in just your own name, then you write down, I am the sole owner. If you and your ex, or indeed anybody else, own it between you, then write that. And if you have agreed the shares in which you own it, write that down too. My ex is the sole owner of the property, so I write that down. But this is also where you say if you disagree with what the paperwork says about who owns the property. I do. I paid half the mortgage and for half of the home improvements for 9 years. I think I deserve a share. Current market value. If you've had your house valued in the last 6 months, you can use that figure. Otherwise, you have to guess based on the prices of similar properties in the same part of town. If you have no idea, ask a couple of local estate agents. Estimate the cost of sale of the property. This includes things like estate agents' fees, conveyancing, getting an energy performance certificate, etc. Most people just put down 3% of the market value. Total equity in the property. This is the value of what is left after you have deducted the mortgage you owe, any charges you have to pay if you repay the mortgage early, and how much it would cost you to sell it. The sum that is left over is what is available to divide up between you and your ex. Sometimes this can be little or nothing, or even a negative amount. And then this last box on the page, the total value of the interest in the family home. If you think you own half of the house, halve this figure and write it here. Okay, section 2.2. This is about any other property, land or buildings you may own or own a bit of. For example, if you owned a holiday cottage or a share in a shop or your home with your new partner, then you need to tell the court that. This page asks for the same information as in the previous section. If you have more than one property, for example 2 buy-to-let properties, you must fill in a separate section 2.2 for each one. At the bottom, you are asked for the total value of your interest in any other properties you own other than the family home. This means how much of the value in these properties you think belongs to you. If you don't own any other land, property or buildings, you can just move on to section 2.3. Here, you have to list all the bank, building society and savings accounts that you have or have had in the last 12 months. This includes accounts in your name and in joint names. So this would include, for example, an account which was opened 8 months ago, even though it is now closed. You have to put down all of your accounts, even those that are overdrawn or empty. It's really important that you put everything down here, as even honest mistakes can increase bad feeling and cause suspicion. It's important to get the most up-to-date balance that you can. In fact, as it will take you a long time to fill in this form, you might want to fill the balances in at the end when you are finished so they can be as up-to-date as possible. The last column asks for the total current value of your interest. This means the amount in the account that you think belongs to you. I have a joint account with each of my daughters, but the money in there is all for them, so I write nil for that. And I still have a joint account with my ex. I think half of that money should be mine, so I'm going to write that figure down. The next section is basically the same but deals with any investments you have, like shares, ISAs, bonds, stocks, etc. If you have stocks, estimate their value using a respectable mainstream valuer, for example, the Financial Times, and write at the bottom, estimated on, and then the date. I don't have anything like this, so I can just move on. 2.5. Now, you have to give details of any life insurance policies, including endowment policies you hold. It's pretty straightforward until we get to, if the policy is assigned, state in whose favour and amount of charge. This means if you've transferred some of this policy to someone else, for example, if you've given 50% to your daughter. If you haven't transferred any of it, just leave it blank. Name of any other owner and extent of your interest in the policy. If the policy is in the name of more than one person, you put the name of the other person or people here. You also say what percentage of the policy belongs to you. Maturity date. Some kinds of policies pay out on a particular date. That's the maturity date. You can find this information on the policy document. If not, ask the company you bought it from. Current surrender value, if applicable. This is the amount of money the company would pay you if you cancelled the policy now. Ask the company you bought it from if your policy has a surrender value and for the current amount. If policy includes life insurance, the amount of the insurance and the name of the person whose life is insured. Okay, so life insurance pays out money on the death of the person whose life is insured. The amount and the name of the person who is insured should be on the policy document, but if it is not clear, ask the company you bought the policy from. Total current surrender value of your interest in this policy. This is the amount of money that will belong to you if you cancel the policy now. Lots of life insurance has a surrender value of 0. Again, check this with the company you bought the policy from. If the policy is in just your name, you will get 100% of the surrender value. But if, for example, 75% belongs to your child, the value of your interest is only 25% of the current surrender value. 2.6. Details of all monies owed to you. Okay, so if you've lent someone some money or you're waiting to get paid for something, this is where you put it. Don't include anything that you've written anywhere else on this form. 2.7. Details of all cash sums held in excess of £500. This is about any cash you've got anywhere that amounts to more than £500. I don't have £500 stashed away in my mattress, but if I did, this is where I put it down. 2.8. Details of personal belongings individually worth more than £500. If you've got something that you could sell for more than £500, perhaps your car, or you have an expensive item of jewellery, or paintings, or a pedigree dog. Before you start listing things, check out their likely resale value online first. Even if they were really expensive, you might not be able to sell them second hand for much. If you do have things that fall into this category, put them down. You can always make sure later that they are not considered part of your assets that can be divided. I don't have anything worth more than £500, so I'm going to leave it blank. 2.9. Details of any liabilities you have. This means debts. The law calls them liabilities. So this is where you put the details of things like your credit cards, store cards, car loans, student loans, any other money you owe. You do not need to repeat any information you have already given about overdrawn accounts or the money you owe on a mortgage. Include the debts that are just your responsibility, as well as any that are in joint names. If you have any joint debts, you need to say how much of each debt you are responsible for. Don't include here any debts that are just in your ex's name. 2.10. Capital gains tax. Blimey. This question is asking you to estimate the amount of capital gains tax you would have to pay if you sold something of value. You might pay capital gains tax on the profit you make when you sell something of value belonging to you. Maybe something like a second home or some shares you own. If you think it might apply to you, you can get more information on the HMRC website, or if you have an accountant, they will be able to help you. If you don't have something like a buy-to-let property or shares, you don't need to answer this question, just leave it blank. 2.11. Details of all your business interests. Complete one page for each business you have an interest in. Okay, so you only fill in this section if you own part or all of a business, or if you're self-employed. If you have an accountant, they may be able to help you with the information you need to complete it. You don't need to give details about the income you get from your business here, you do this later. 2.12. List any directorships you hold. This is only for people who are directors of companies or corporations. If you're not a director, then just move on to the next section. 2.13. Give details of all your pension rights and all PPF compensation entitlements. So this section asks about information about your pension. If you only have a right to a basic state pension, you don't need to fill this section in. If you have any other pensions, you will need to contact your pension provider and ask them for a valuation. They should also be able to help you with answers for the questions in this next section. Beware, public sector pensions can take a very long time to give you evidence of your pension valuation, often 3 months. So you want to get on with asking for this as soon as possible. Make sure you keep evidence of your request, a copy of the email or letter, so that if it hasn't arrived in time, you can prove that you did all you could. When it asks about CE, it means the cash equivalent. This is the amount of money that the managers of your pension scheme could transfer into another scheme. When it asks, is the pension in payment or drawdown, it means, are you getting any money from it, either regular payments or drawdown is a way of taking money out of your pension without having to buy an annuity. Is the PPF compensation capped? This is about where pension providers have gone bust. If you've never heard of PPF, it's not something you need to worry about. Give details of any other assets not listed. Okay, so this is where you give information about anything else you own or own a share in, whether it's in England and Wales or anywhere else. So this means literally anything of value, anything you have in a trust, anything you have loaned to somebody, anything at all. It also includes things that you don't own but expect in the near future. For example, if you're expecting a compensation payment, or if somebody has recently died and you know that you're definitely going to inherit from them. If at any point on this form you are not sure if something would be relevant, put it down and the judge can decide. 2.15. Details of earned income from employment. Okay, so this is relatively straightforward. Find your P60 and all the details are on that. If you have 2 jobs, you have to fill in this page twice. Gross income means the amount you get paid before tax, national insurance, etc. 2.16. Income from self-employment or partnership. You have to fill in this section if you are self-employed or in a business partnership. If you have an accountant, they should be able to help you with the information you need. 2.17. Income from investments. Okay, so in this section you give details of any income you get from investments, or for example, a buy-to-let property, holiday home, caravan, shares, high value interest accounts, etc. Again, I don't have any, so I just move on. 2.18. Details of all state benefits you are currently receiving. Okay, so the only tricky thing here is to make sure you know which of your benefits are paid every 4 weeks and which every calendar month. For example, child benefit is paid every 4 weeks. I get the income for the next 12 months for that by timesing that by 13. If you're in any doubt, ring the DWP. 2.19. Any other income. Okay, so this is where you put down any other income that you either received in the last year or you will receive in the next year. Remember, if you are ever not sure if something is relevant, just put it down so the judge can decide. 2.20. Okay, so on these pages you just fill in the total amounts from the previous pages. You can see at the bottom here, total A. Then add A, B, C, E, F, G up and then subtract the amount of your debts, which is the total for D. Be careful not to accidentally add your debts as though they are positive figures. 2.21. And then this next box is similar, but it's the summary of estimated income for the next 12 months. So I just go back through the form and find the figures I had as totals for H, I, J, K and L. Right, so that's the end of that section. Part 3, financial requirements. Okay, so this part asks about how much money you and any children living with you need to live on. Before you start this section, you need to work out how much money you're going to need. Advice Now have produced a checklist to help you. It's part of their written guide to dealing with this form, how to fill in a financial statement without the help of a lawyer. You can download it here at www.advicenow.org.uk/Form E. Once you've had a good long think about that and filled in the checklist, we'll get started on this next section. When you're working out what you need, try to think about things that you might not need straight away, but you might need next year. For example, at some point you may need to replace your washing machine, so you need to factor that in. 3.1. This asks whether you've calculated your income on a weekly, monthly or annual basis. Once you've decided, don't mix them up. This bit also asks you to tell the court if the income you need for you and your children is likely to change in the near future, why it is changing, and an estimate of the cost. So, for example, if you know your energy bills or mortgage are about to go up, tell the court here and estimate how much more income you will need to cover the additional expense. 3.1.1. Income needs for yourself and any children living with you. I've used the template produced by Advice Now, so I'm just going to write the total in here and attach the full checklist so they can see where I got my figures from. 3.1.2. This asks about any separate income needs for the children. You don't need to include their food, heating, etc., as you've included the expenses for the whole household in the box above. But if they have any expenses of their own, you should include it here. This might include school fees, swimming lessons, school trips, etc. 3.2.1. This section asks about your capital needs. Capital is a chunk of money. You may need a chunk of money if you're going to buy a home for you and the children to live in, or, for example, to buy a car to get you to work. In this section, you explain what you need and how much it will cost. 3.2.2. If any of your children have separate capital needs, for example, for a car, a wheelchair, a computer, you identify these here as well as the cost. You need to show how you've estimated the cost of each item, perhaps from a range of online prices for the same item, and that it is reasonable. The court will think something is reasonable if it's in keeping with what you're used to. So, if you're used to driving a Ford Fiesta, the court will not think it reasonable that you now need a Porsche. If neither of you has any money to meet your capital needs, you can leave this section blank. You may have needs, but unfortunately, in practice, they are not going to be met. Okay, so on to part 4, other information. 4.1.1. This bit asks you about any significant changes to your finances that have happened in the last 12 months. So you have to say here if, for example, you won the lottery 10 months ago, you gave something very valuable away, or your pay has changed substantially, or you have had £10,000 in savings 3 months ago, but now you only have 250 quid left. I've spent all my savings, so I put that down. 4.1.2. So this next bit asks you about any significant changes that are likely to happen within the next 12 months. So for example, you have to say if you're going to be made redundant, or get a big bonus or pay rise, or if your mortgage payments are going to go up because you've come to the end of a fixed rate, or say if one of your children is about to become 18 and you'll lose child benefit. If something significant changes after you filled in the form but your case is still ongoing, you still need to let the court know. It's not worth pretending you didn't know about something. 4.2. Brief details of the standard of living enjoyed by you and your ex during the marriage civil partnership. Right, so this is where you give the court an idea of what you've been used to. If you've had a regular foreign holiday every year, or something like a cleaner or babysitters, this is where you include that and say how often. It might also be useful to include what your average monthly food shopping bill came to, or what sort of car, if any, you had. 4.3. 4.3 is asking about particular contributions to the family property, assets or outgoings, or to family life. So, for example, if you worked only part-time in order to look after the kids, you should put that down here. Or if your parents gave you money for the deposit when you bought a home, or if they pay for things like family holidays or school trips, you should put that down. Or if one of you brought considerably more money to the marriage than the other, things like that should go here. Okay, on to section 4.4. So this is where you say if your ex's past behaviour should be taken into account in deciding how to divide up your money. For most people, nothing is going to be bad enough to be relevant here. The court won't consider having had lots of affairs as bad enough, so it's not worth putting that down. It has to be really, really bad, or behaviour that affects your finances. For example, if your ex sexually abused the children, or left you with injuries that meant that you couldn't work, or had something like a gambling problem that left you with no money, then you put that down. Before you include any information here, you might want to get legal advice to see if it's relevant. The risk is that if you put something that is irrelevant, it might create anger and more bad feeling, and that will make it harder. So, next section. 4.5. Give details of any other circumstances that you consider could significantly affect the extent of the financial provision to be made. Okay, so this is where you include things like if there is something that limits the amount you can earn, perhaps ill health or looking after the children. If it is likely you might get made redundant or retire, or if you have one elderly parent from whom it is likely you will inherit soon, or if you have plans to marry again or move in with your new partner. Stuff like that. 4.6. You only need to fill in this section if you have remarried or formed a new civil partnership, or moved in with a new partner, or if you plan to do any of these things. If you have or plan to, then you need to give details of your new partner's financial circumstances here if you know them. If you don't know them, you don't have to give them, but the court may assume your new partner is contributing to your living expenses. The court wants this information because it may help the judge make a fairer decision. It is not usually about you getting less because you have a new partner. It is more likely to be about when you get your share. So, for example, If you can live with your new partner in their home, then the court may say you have to wait to get your share of the money from the family home until your children have grown up and moved out. Part 5. Order sought. In this section, the court asks about what kind of court order you're looking for. It's a good idea to get some legal advice or say that you want full disclosure. Basically, you want to see what your ex has before you decide what you want. I know I'm suggesting the house should be sold, so I write that here. I don't think I want maintenance payments, but I might need them to make ends meet. So I'm going to put down here, I don't think I want maintenance payments, but I want to keep that as an option. Anything that doesn't apply to you, you can just leave blank. Okay, statement of truth. We're nearly finished. I cross out this bit, the applicant respondent believes, so it just says, I believe the facts stated in this statement are true. I cross out the next line, as that would be as if a lawyer was filling in this form for me. Then I complete my name, finally an easy question, my postal address, and sign and date it. If your ex has a solicitor, put the name of the firm inside this box here. If they don't, just leave it blank. And you can ignore the position or office held box. Last page. This lists all the documents that you'll need to send off with this form if they are relevant. Things like bank statements, mortgage statements, insurance policy documents, and details about your pension. If you don't have all the documents that are supposed to go with it, tick the To Follow box and try to get them later. It's a really good idea to keep copies of any emails or letters that you write asking for evidence. And if you phone, make a note of the date and time, the person you spoke to, what was said, and keep it safe. That way, if nothing arrives in time for your first appointment, you can show that you asked for it and that it's not your fault. Now, remember to go back and fill in today's date on the first page. If you haven't written in the balances of your accounts in section 2.3, remember to do that now. It's a really good idea to make a copy of this form. So I'm going to take it somewhere to get photocopied, and then all I need to do is send it. You can find more help at www.advicenow.org.uk/going to court. Good luck.